Appellate Division Court Department. Hear ye, hear ye, hear ye. All persons having business before this court will draw near, give their attendance, and they shall be heard.
Please be seated. First case for oral argument this morning is 743 People versus Dwayne Tucker.
Good morning. May it please the court, Dave Juergens for Dwayne Tucker. Under point one, the felony murder conviction, the trial proof was insufficient to establish three of the elements. The people do not really address two of the elements, that the victim's death must be caused in the course of and in furtherance of the underlying felony, in this case, a robbery offense. Was this robbery? We need a forcible stealing. Any force used here, was it necessarily to steal property?
Mr. Juergens, if I might, see, I kind of read the transcript of below. The defense counsel said something to the effect at trial. I don't mean to take you off your game entirely, but what's interesting to me is where he said the crux of the case is the text messaging. And see, I look at those first points in your brief really kind of coming down to that is sort of the crux of the case, because if you put that together, then there's evidence of the robbery in there too, right? So even though I know they're later on in your brief, I'm wondering if that's the focus of the appeal, the text messages.
Well, the text messages definitely under points 3 and 4, we're arguing were inadmissible because the proof didn't establish who authored either set of text messages. In particular, with respect to the Samsung cell phone, the people did not establish a prima facie case of conspiracy so that the co-conspirator exception to the hearsay rule would apply.
The critical issue then, if I have it correctly, and correct me if I'm wrong, is whether the court abuses discretion in finding that there was an adequate foundation for the competency that the text messages are what they purported to be. That's sort of the key issue in the appeal, isn't it?
Well, it's the court erred because they didn't establish authorship based on what was before the court. These are text messages that occurred 2 days before the shooting. The only proof that they had to connect Mr. Tucker with the HTC cell phone was the fact that he possessed it 1 day after the shooting,
But
3 days.
counsel, the question of who wrote the text messages, that doesn't go to admissibility, does it?
I believe it's a foundational requirement, and if they don't establish, I mean, the text would have no relevance if they don't establish who authored the text messages, and I believe I cited a couple of cases in my brief where it's saying unauthenticated text messages have no evidentiary value at all.
Well, no, but I agree with that, unauthenticated. So, but the question is, does this question go to the foundation or does it go to the weight?
I think it goes to the foundation. I think that they need to establish basically that there was exclusive control over the HTC cell phone 2 days before the shooting to have an inference that Mr. Tucker was necessarily the author of those text messages.
We'll look at that very carefully.
And I would, simply note as I shift that anyone can type a text message, and there was nothing specific in these text messages that were unique to Mr. Tucker. Certainly, there was no, he wasn't the subscriber on this account. There was no showing that this was a password-protected account. But going back to, even if the text messages come in, that doesn't establish that there was sufficient proof of felony murder. You have the whole issue of what proof did they have of Mr. Tucker's actual participation in this crime. The proof was entirely circumstantial. He wasn't identified as being...
Getting back to the text messages, if the jury were to accept that lick means robbery and accept the fact, the inference that the phone was in the possession of your client at the time of the robbery, there's certainly reference to robbery in the text messages. That's why I come back to the idea, Mr. Jurgensen. I get where you're coming from. You've got to make these arguments in a certain way. I respect that. But that's why it's an interesting issue about the text messages. And I still think that's where the case rises and falls.
It's definitely an important aspect of the case. I don't believe that there was any proof that Mr. Tucker possessed the cell phone at the time of the shooting.
And again, Mr. Jurgens, you've been through all that, so we understand your argument there.
Okay, well, with respect to, and I won't reiterate the circumstantial nature of the proof, I would ask the court to consider under point 2 that if you're acting as a second jury, that you should be considering whether the proof excludes beyond a reasonable doubt any reasonable hypothesis of innocence. That's
and we know that.
Okay. Well, if the court has no additional questions, I'll rest on my brief.
Thank you.
Morning, Your Honors. May it please the court. Justice Curran, going to your point first, I agree that the text messages in this case were probably the most incriminating piece of evidence presented. However, I don't know that I would go so far as to say that the entire case hinged on those text messages. There was a substantial amount of additional evidence going to the intent of the co-defendants when they went to the house on Santee Street.
Again, though, circumstantial.
Oh, I would agree. Yes, it is circumstantial, but circumstantial is, I would say.
But once you move off the text messages, then as Justice Smith points out, it does become all circumstantial, which is Mr. Jurgens' point that, wait a second, if you look at that, it may not be sufficient, maybe against the weight. Again, I don't want to pigeonhole it that this is all about the text messages. I know that it was a lengthy trial. There was a lot of proof. But at least for me, that's the most interesting issue in terms of what it seems to hinge on.
I understand it.
And you would say that we established a sufficient foundation to prove that that they were what they purported to be, text messages that came from these cell phones.
Again, Judge, the extraction that was performed on those cell phones, the data, the text messages were taken directly from the cell phones that were in the possession of the defendant and the co-defendant. My position is that that fact alone is sufficient foundation to admit the text messages. The other arguments, as Justice Peredato pointed out, do go to the weight that should be given to those text messages, but I believe that's a weight issue rather than a foundational issue.
Anything further?
Unless there are any other questions, then no.
People versus Rondell Johnson.
Oh, I'm just. May it please the court, Ben Nelson for Mr. Johnson. I think we're in agreement that the reversal of the co-defendant's appeal controls here. I would just point out, since
And
it's
the people
important.
concede, the people, in this case, the people
Yes.
concede that the court
They do.
erred in entering into a cooperation agreement.
And I don't see any basis to distinguish. I would just mention, since it's important to my client, that he has sought additional relief in his pro se supplemental briefing.
Thank
So
you.
I commend your attention to that.
Morning, Your Honors. Lisa Gray for the people. Yes, the court is correct. At this point, the people do concede that reversal and a new trial in front of a different justice is warranted in this matter. Unless there are any other questions, I would rest on my brief with respect to Mr. Johnson's pro se brief.
Thank you.
Thank you.
People versus Thomas Newsom.
Morning, Your Honor. May it please the court, Johnson Randall for the appellant. This is an appeal from a conviction for the criminal sale of controlled substance following a guilty plea. The only issue, I think we've raised everything in our brief. The only issue I'd like to discuss this morning relates to the defendant's letter to the trial court. And we feel that the trial court should have had some discussion about that letter at the time of the guilty plea, insofar as the defendant's issues with counsel and the failure to notify the court of his mental health issues, and the fact
Mr.
that...
Sarando, after the court received that letter, new counsel
New
was
counsel-
in fact
yes,
appointed.
Yes,
Okay.
but I think some of the things that he related concerning his, as he phrased them, mental health issues, the trial court never inquired at all at the time of the guilty plea, and I think that affects the voluntariness of the plea.
Mr. Sarando, is there anything in the plea colloquy that would have led the court to believe at that time that they should look further into his mental health?
Well, he said, you feel you're under any mental distress? And the defendant said no at that time. But the court did have in its possession the letter, and I didn't see any discussion at all in the plea colloquy about that, about the issues that he raised. So we submit that that goes to the voluntariness, and it should be reversed.
Thank you.
Thank you.
Good morning, may it please the court. Chris Eagleson in response. We will rest on our brief, but I'm happy to answer any questions.
Thank you.
Thank you.
People be Sean Bembry. Ms. Mervine, it looks like you were going to submit.
Yes, Your Honor.
Okay, thank you. That's submitted. People versus Artis Miller.
Good morning, may it please the court, Brad Keem for defendant appellant. I'd like to discuss a couple issues starting with the sleeping juror. We recognize that the issue is not preserved by defense counsel inquiry into the sleeping juror, but the interest of justice review is appropriate because the record is clear that the juror slept for 15 minutes.
The prosecutor actually raised the issue with the court, and the defense counsel seems satisfied with how the court handled the issue.
Well, I would say that defense counsel did not object, but the interest of justice is still appropriate when it's 15 minutes of, it's not dozing, it's 15 minutes of sleep. And the prosecutor portrayed it, described it as important testimony that this juror missed. So the trial court, its proposed remedy was insufficient. It needed to inquire as to what was going on with this sleeping juror, whether rewinding the tape was appropriate, whether determining whether this juror had some kind of issue.
But again, none of the defense counsel never asked for any of that below.
I understand that, Your Honor, and that's why in this kind of situation where we're talking about important testimony that the prosecutor.
The court, you're saying pretty much that the court has to take over.
I would say that it has a duty, given these circumstances, to inquire. If this court does not agree with that issue or the other issues raised, it should still remit the matter for a restitution hearing. The people concede. Again,
that hearing was not requested by defendant.
It was not requested, but I think we have an even stronger issue in terms of preservation here, because asking for preservation is unfair, where defense counsel told the trial court he needed to discuss the restitution issue with appellant. The record does not indicate that a discussion took place. There was no adjournment where appellant and counsel discussed this. And then the trial court claimed it would wait to hear from defense counsel before signing a restitution order, and then moments later imposed restitution.
Can it be concluded that the defendant impliedly conceded to the restitution amount?
I think that would be a tremendous jump by the trial court to do that when just moments later it had said that it would not sign that order without hearing from defense counsel, and the record is simply silent as to.
Didn't the court even articulate the amount that it intended to impose absent a hearing or absent an objection?
It did.
And so everybody knew what was going on here.
They did know that it was $3,293.83. But again, I think that requiring preservation here was unfair, where there was nothing on the record. Okay, unless there's any other questions, we'll rely on our brief. Thanks.
Thank you.
Good morning. Dan Gross for the people. Both issues raised on oral argument are unpreserved for this court's review, although counsel suggests that this court should sua sponte inquire into the sleeping juror, that a record is required to be made by the defense counsel. The cases relied on by defendant show that defense counsel either asked for further relief, or the court itself made the finding that the juror appeared to be asleep. Neither of those.
If defense counsel liked the juror,
yeah,
it would have been a problem if the court intervened and did something about it.
I agree. That would almost infringe on the Sixth Amendment right of the defendant if the court sought to excuse that juror over defense counsel's request or strategy or other legitimate reason for keeping that juror. The same can be said for the restitution hearing, where, as Justice Joseph pointed out, there was no surprise here. The amount was the amount, and if there was any issue that was going to be arise, the court gave a remedy for the defendant to follow up, and no restitution order would have been signed, and that didn't occur in this case.
Thank you.
Thank you.
People versus Rafael Nieves-Cruz. Nieves-Cruz.
I think it's Nieves Cruz.
Pardon?
Nieves Cruz. Nieves.
I got it.
Got it?
Nieves. I tried. Nieves.
It's appeal from a conviction for the crimes of criminal mischief, declared an OGA following a jury trial. I think the one issue I'd like to begin discussing it relates to the uncharged crimes. There were more uncharged crimes than there were charged crimes in this case. And I really don't believe that the 5 prior incidents of his conduct in the jail were needed to show his intent in regard to these 2 charged instances, or the absence of a mistake, or to complete a narrative. They were just improperly used at trial. And I believe under the rationale of Judge Pigott in People versus Finch, I think that's the name, the fact that the defendant, at the time of the motion or the application was made, objected to it, I think that would be sufficient to preserve the issue for this court as a question of law. And we submit that the trial court really abused its discretion in these unrelated incidents. The crimes charged were specific crimes, and we submit that it was overbroad as far as the uncharged crimes. And as far as the crimes itself, I think when you look at the videos, I don't believe there was OGA, and for the criminal mischief, the jailer testified there were no unusual sounds, and you needed pliers to remove the shower heads. That was the alleged instrument.
He was the only one in the cell at the time, correct?
He was the only one in the cell. We don't know the condition of the cell when he went in there. I don't believe that was in there, Judge.
We'll look at that very carefully.
Yes, and other than that, we'll rely on our brief.
Thank you.
Thank you.
Good morning, may it please the court. Chris Eagleton in response. I do believe that there was a record testimony regarding the fact that he was not just the only one in the cell at the time, but that the broken window that's the subject of the criminal mischief was not broken at the time he was placed in, and that nobody else was in that cell but the defendant when they discovered the window was broken. As for the matter that the shower head believed to be used as the implement to break the window needed pliers and that no pliers were available, I believe the testimony is clear that when the corrections officer reached up, he was able to pull it off merely with his fingers. So clearly it was available as the weapon in this case, or the instrument, I should say.
And then the Molyneux, it's a question of discretion, correct?
Yes, Your Honor. A question of discretion. In this case, there were 32 and other instances of other bad conduct, and only 5 were admitted and limiting instructions applied. I also think, Your Honor,
the intent to resist or obstruct, the absence of mistake with respect to the destruction of the property, completing the narrative with respect to why there's a need for so much security. In the video, there's 5 or 6 guards are taking him out. So that's the point of the offer, correct?
It is, Your Honor, and completing the net especially, since those officers were dressed in essentially combat gear, it was described as combat gear at trial, and you can see it on the, gloves, the mask, all of it. It might lead to, a jury has to get a full and fair picture, right? And it might lead a jury to think, that they were behaving in such a way toward the defendant that somehow excuses his subsequent behavior. So they should have a fair understanding of why the officers were dressed the way they were and behaving the way they were.
Thank you.
Thank you.
People versus Michael Bell.
Good morning again. Ben Nelson for Mr. Bell. In our view, this court should have grave concerns about the nature and the quality of the evidence supporting this conviction. Obviously, the way you can exercise those concerns is through your weight of the evidence review power. Although,
Counsel, but didn't the jury have a chance to assess all of these witnesses, flawed as they were, in coming to their ultimate decision in this case?
they did, Your Honor. Of course, this court still has its own power and obligation to exercise. I would argue that you have a better opportunity to evaluate the credibility of Devin Mason, because unlike the jury, which by the time they were confronted with Devin Mason's testimony for the first time, he was able to cure the absolute, unequivocal contradiction by objective evidence that his testimony at the Rodriguez hearing created. This court and county court was confronted by that before trial. It's a very unusual posture where the pretrial hearing point one of our brief, basically puts the question before you that is the question in this case: is this man's testimony worthy of any belief? And so if I could, I'd like to spend a second addressing that point. I don't think it suffices.
I do think that, it's very clear that there were some inconsistencies. He said that he saw a defendant every day for the last 4 or 5 years, and yet he was in jail for 2.5 of those 5 years, et cetera. And we understand that. But my question goes back to my earlier comment. Didn't the jury have an opportunity to evaluate, whether any part of his testimony was true with regard to his knowledge of the defendant, what he looks like, and what he saw that night?
The jury, yes, they did.
And how would we be in a better place to determine the credibility of the witness in the jury?
Well, you have the time and the ability to examine the contradictions that he made internally between other witnesses. And and
the fact that he was fighting for his own preservation in a different case, that he had some self-interest in what he was saying to the jury.
That's certainly significant. If I could just make a couple of observations that I think should guide your evaluation of credibility in this case, that struck me as significant. His testimony was contradicted by James Lewis's testimony in key aspects. Mr. Mason testified that Mr. Lewis was nowhere around Walter Park, the shooting, the dice game, despite Mr. Lewis giving a much more consistent with other.
We've gulped at all that very carefully.
I understand, Your Honor. It's a significant record and a significant case with consequences for my client, so I wanted to make a couple of observations. One aspect of the testimony, or rather I should say, an exchange between counsel and the court during the testimony seemed to be significant. This was when there was an exchange about how defense counsel was going to be able to confront Mr. Mason with impeaching him with his prior written statements, his plea agreement, given that he had just told defense counsel, I can't read. During a sidebar, the court asked the prosecutor, is that true? Did you know that he couldn't read? She said, I don't know either way. I find that astonishing, that this is a witness who has multiple prior sworn statements on paper, 2 forms of testimony at grand jury and the hearing, plus his police statement. The only way to me it seems that that statement could be true is if the prosecutor had taken essentially a see no evil, hear no evil, hands-off approach to whether this witness, who contradicted himself at trial between his own prior statement, added a new allegation about having witnessed a car pull up and an exchange of a gun that wasn't given to an investigator who had every reason to record that. I just don't know how it could be the case that in preparing this, I'm prepared to call it a single witness case, and the people were not willing to indict it for 6 years until this witness came forward, how you could not be aware whether he had the ability to.
Well, it's a single eyewitness case.
Yeah.
I mean, there's lots of other circumstantial proof, but you're right. Mason was the only person who said, who identified the defendant as the shooter.
Agreed. So
And
we really.
we've gone through each and every bit of this. We do understand.
I do. If I could just comment briefly on the third point in our brief, the missing witness instruction. We don't think it should need to be reached, but if it is, the county court made errors in its sort of combined assessment of both control and cumulativeness. I think Court of Appeals' decision in Smith is relevant to both points. Control was established by the fact that this was a people's witness on the witness list right up to the last minute.
Okay, but then that witness seemed to turn, and the defense was given an opportunity to speak with that witness. In other words, the control thing, the defense could have called, I mean, that witness was there to be called by whoever wanted to call him. They had moved her to the jail so that she could testify. Okay. I had it in my mind that it was a she because the name was a little feminine, sorry, or whatever. But the witness was moved closer. Anybody could have called that witness.
Respectfully, Your Honor, that has no bearing on whether a missing witness instruction must be given.
But Justice Bannister's point is that the witness turned. The witness then later provided a statement saying that he could not identify the defendant as the shooter. And so it seems to me that all the elements of the requiring the missing witness charge were no longer present.
Well, control is not determined by whether the account that the witness in fact gave and the account the witness.
We understand that. But the witness was there and could have been called by the defense at any time.
I thought I was addressing a different point, which is whether does the witness, having given a statement by the very end, contradictory to what the witness had originally given immediately to investigators, does that switch control? And I think you'll find that if you read Smith and Gonzalez, it does not. Rather, you look at whether are there any circumstances of the relationship of the witness to the defendant or the defense that you would expect that witness to be favorable to the defendant or the defense. In fact, all that happened here was that the people learned that based on what the witness said at the very end, that witness's testimony would probably not be favorable to the people.
Why isn't that accurate?
That's exactly accurate. That's exactly the inference that the missing witness instruction tells.
Why don't you listen to Judge?
I apologize.
Well, it seems to me if the testimony was not going to be favorable, that it seems to me that there is no longer control over that witness.
I disagree, Your Honor. Control is analyzed by whether, given that the witness expressed no affiliation with the defendant, but only with the victim or the police in solving this murder, would you expect based on that, and also stated that I saw it, would you expect that if the people had no fear of the honesty of that witness, they would call it? And that the inference that the missing witness instruction tells the jury it can draw is if this testimony was going to be favorable to the people's version of events, people would call that witness. And that's exactly what they admitted.
But I think the point is that maybe it wasn't going to be favorable to them any longer.
Yes, I agree with that, but that's precisely, it seems that where we disagree is whether that means it's precisely why the missing witness instruction is so.
And that's what we'll have to look at it, and we'll have our interpretation, and we'll see.
Thank you.
But I certainly found this case very interesting, and if anybody was ever going to write a law school exam on criminal law, they could use, this as an example. It was a very interesting and difficult case.
Good morning. May it please the court. Leah Marvine on behalf of the people, and I would agree, Justice Bannister, it is a very interesting and difficult case, as is often the case in these types of homicides. I would just note that if this court were to accept that it was in a better position to analyze Mr. Mason's testimony, And again, reminding this court that he was approximately 15 years old at the time of the homicide, by comparing the Rodriguez hearing, which in the people's opinion should have never happened, as the 7/10/30 notice was adequate in this case. But in any event, if this court could compare the Rodriguez hearing with the trial hearing, it could also look at Tremarius Seymour's statement that's in the record where he identifies the defendant as the shooter. And insofar as the control of Mr. Seymour, he did not only recant to the prosecutor, but he also provided a written statement to the defendant that the defendant retained sole possession of. And that was prior to the new discovery and Rosario rules. Therefore, the people had no way to ascertain what Mr. Seymour had said in that paper. I know the court is fully aware of the facts. This case was not against the weight of the evidence. It was given the careful consideration by a jury that it deserved, and the people would ask this court to affirm the murder conviction.
Thank you.
Thank you.
People versus Pandy Trivanovsky.
Good morning again. May it please the court, Brad Keene for defendant appellant. We submit that appellant established the extreme emotional disturbance defense, and I once again do not have a preserved issue, but I would ask that this court review it as part of its weight of the evidence review or in the interest of justice. First, we assert that the evidence reflected that appellant subjectively lost control. The deceased would not leave appellant.
They were fighting over the location of some gym equipment?
That's how the fight started, yes. And I know this court has reviewed this record, and it's incredibly sad. These kind of vocal battles occurred over years and decades. And this one was extremely trivial, but it was a powder keg. You know, what she was saying to him eventually set that powder keg off. And I think the medical evidence reflects that when he did hit her, it was indiscriminate. There was no intent. It was all over her body. When you look at...
I think, looking at those photos, I think it clearly shows some intent. Those photos were pretty grisly.
Absolutely.
We're not talking about a swollen lip or a scratch on someone's face here.
Absolutely not. But what I guess what I'm trying to impart to the court is that it was uncontrollable and it was all over her body. It wasn't to, it wasn't as a means to an end to kill her. And then when you look at the reasonable explanation, and I know this court is well aware of this history of the fact that she wouldn't share food with him, forcing him to take food from an Albi's dumpster, that the son and her would team up, that the son's testimony was pretty chilling, how terribly they treated him, pushed him around. And I'm not trying to say that he was innocent here at all, but they made his life very difficult. And that's why even if this court rejects our EED argument, it should look at the sentence, in particular, looking at Penal Law 6012. That
wasn't requested either, was it?
It was not requested, but I think as part of this court's independent duty to review the sentence, it should consider 6012 and the fact that appellant, was verbally and physically abused, and such abuse was a factor in the instant offense, along with he's 72, he has multiple health ailments, he doesn't have a criminal record. These kind of things should lead the court to reduce the term of imprisonment here. Unless there are questions, we'll rely on our brief.
Thank you.
Good morning, Your Honors. Ken Tyler for the people. I'm prepared to rest on my brief. The record was strong. The jury rightly rejected the EED defense. Probably found that notion offensive in light of the strength of the proof. I ask you to affirm.
Thank you. Stacy C. Bauer versus Jacob G. Daly.
Good morning, Your Honors. May it please the court. After an 11-day trial over a 23-month period, family court dismissed the violation petition on the grounds that the time had been made up and the mother's counsel was not asking for jail time without making any factual findings, credibility determinations, or conclusions of law. This decision was made before reviewing all of the evidence while the mother's counsel was in the middle of cross-examining the father. I don't have anything to add to the contentions I made in my brief, but I would like to address issues made in and omitted by the AFC's brief. Even assuming that the mother's visitation was made up months later, this does not make her whole. She was still prejudiced and her rights were still impeded. For example, the children could not attend her family reunion, an event that was extremely...
We understand that there's things that happen here. This is a very unusual case, and we get that, but the time was made up, and I don't know if sending him to jail or imposing a fine, it might hurt the children more than it would hurt him.
But I think he needs to be held accountable for his actions. What he did by withholding all visitation, and I'd like to point out all communication between the mother and the children during this operative time period in the summer. The communication aspect can never be made up. And like I said, the family reunion is that opportunity cannot be made up. So I think, when you consider whether to find him in civil contempt or whether this is a willful violation, that I am respectfully requesting that the court consider that a finding of a willful violation or civil contempt would have lasting implications with these two parties if there are additional proceedings in family court in the future. Thank you.
Good morning. This is Susan Gray, attorney for the children in this case. I think it's important to update the court that after the violation petition was dismissed, the custody proceeding continued, and after a conclusion of that hearing, that petition was also dismissed by Judge Reed, as the mother had not shown a change of circumstance. I certainly agree with the court that a finding of contempt, jail time, or a fine would affect my clients. They are still primarily in the care of their father, who has primary residence. The children are doing well. It's the first day of middle school for my oldest client, and the first day of school also for my youngest. So unless the court has any questions, I would rest on my brief and the cases cited therein.
Thank you.
Thank you.
In the matter of Tony S.H. Jr.,
Johnson Randall for the New Hope Agency. I thought Mr. Stenoff was apparently submitting. So I think when you look at the family court's decision, it fully covers the best interest analysis, and
Well, I think the question is whether the court should have even gotten there. You agree this is an extrajudicial surrender.
Right.
And it's undisputed that the mother timely revoked her extrajudicial surrender.
And the contract itself on page 27 of the record said that the right to return may depend on the best interest hearing.
I don't know that helps you, because the contract didn't have the required language about the surrender being a nullity if the mother revoked within 45 days.
Didn't the court take care of that in the, what was the name of that case? State ex rel Mary Beth versus Catholic Family Center?
That pertained to a different statute.
But but it still found that the best interest hearing was required. And
Was that, I don't have that case in front of me, but my recollection is that was a case that involved an extrajudicial adoption consent, not a surrender.
well, this was
Different. I mean, the consequences that flow from those two statutes are different.
Well, she sought out the agency, she chose the prospective adoptive parents.
Nope, I don't disagree,
And
but she revoked her surrender. And so the question for us is what the impact of that is.
the impact of that is a best interest hearing.
It's not what the statute says.
No.
It says it's a nullity.
If it's a nullity,
It says the surrender's a nullity.
but I think,
And it doesn't say anything about going to a best interest hearing.
I think if all that will do is if the child goes back to the birth mother,
Well,
DSS is going to take the child away.
well, so that would be my questions. If we do determine that the surrender is a nullity, the child, of course, has been in the custody of DSS for quite some time.
No, not DSS,
I'm sorry,
in custody of the agency.
right,
or
with the agency.
With the
new-
adopted parents.
Right.
Who the mother chose. And so I think in that situation, you may get to a best interest hearing. Or family, or DSS will take the child from the mother and place
Well,
the child.
may commence a TPR proceeding or something along those. I mean,
Well,
you know,
I don't think it's may. I think the witness testified that they will, because her 5 other children were removed from her.
right. No, we're aware of that.
So that takes the child away, and then that takes the child away.
The child will, if we do agree that this is a nullity, the child will remain physically replaced or replaced with the respondents. Yeah. Until something else
Well, then,
happens, which is, of course, outside of this
then you'd have
record.
to have it, you'd have to have another best interest hearing.
And that may be what
But
happened.
that'll be a different proceeding. and that's-
It's almost like a WPA project for lawyers. But really,
We understand that, but.
practically, I don't know if that's necessary on this record, with the findings that the court had as to the total unfitness of the parent.
Thank you.
We'll rely on our brief, thank you.
The next case, I'm going to call 753 and 758 together, if those two cases. And then what I'm going to ask is that Mr. Mastrolio, if you want to argue both first, and then the two sides can take turns. Oh, and I'm sorry, and Justice Joseph is recused on this matter.
Thank you.
Is that okay to do it that way?
Yes, absolutely, Your Honor. Thank you. Your Honor, this case is about who controls police and fire discipline in the city of Syracuse. It's not disputed that the city is a city of the second class, as that term is defined by the second class cities law. It's not disputed that the second class cities law controls or governs cities of the second class.
It's always a treat when we go back to the early 1900s and start figuring this out from the beginning, Mr. Mastrolio.
Absolutely, Your Honor.
But getting to what I think.
You and I probably remember the early 1900s, so go ahead.
Getting to what I think maybe is sort of the crux, and I got in trouble in the earlier case by calling it the crux, but doesn't it come down to what our interpretation is an application of the 1960 charter? Did that effectively, forgive me for stopping and not finishing the question, didn't that effectively adopt the disciplinary mechanisms of the civil service law? And then once the city did that, it then is subject to the Taylor law. That's really what I understood Justice Carol understood of these two cases. And what's your response to that, sir?
Sure, Your Honor. Thank you. So first of all, I think you have to consider that issue in the context of the legal decisions that have been coming from the Court of Appeal since 2006. So we see, the progression from Police Benevolent Association all the way to City of Schenectady. And I think City of Schenectady.
All of which caused the parties to hold fire on this issue until now, basically. So.
Yes, Your Honor. There was an acknowledgement of those cases in the parties' collective bargaining agreement. So that, that's one of the reasons it's coming up now. But in any event, if you look at the City of Schenectady case, you see historically these changes to the City of Schenectady charter, elimination of the position of Commissioner of Public Safety. All of these things that the City of Schenectady did to go away from the second-class cities law. And one of the issues that was considered in that case is whether those changes were enough to supersede the second-class cities law. And that's what we're dealing with here. Did the 1960 charter supersede the second-class cities law?
And the 60s charter specifically references the procedures in the civil service law. And I don't know if it's in this record, but it's certainly in the companion record. There's an expression of intent, as I understand it, of the city to do exactly that.
So I think there are a couple of reasons why that is not the case. First of all, if you look at the progression of that disciplinary provision from the 1915 charter to 35 to 60, you see the first paragraph remaining essentially the same. The chief of fire and the chief of police retains the power to promulgate these disciplinary rules. Why would the city retain that power in the chief if the civil service law was going to control? So that's one thing.
But isn't the comeback on that, why reference the civil service law if that's what you're going to do? But they did.
Well, I think that the civil service law, it can't be taken out of context. You have to read that entire disciplinary paragraph from the 60 charter. It starts by saying that the chief possesses the power to promulgate these rules. Then it says that these rules or the disciplinary procedures have to be in accordance with the rules and regulations of the department, all other laws, including the civil service law. So I don't think that it's necessarily saying we are adopting the civil service law, which, by the way, had no bargaining obligation at that time because the Taylor law hadn't been passed. So number one, I think you have to focus on the fact.
It doesn't say it's adopting the civil service law, but it says that it is to be followed, right? How do you get around that? I don't know how you get around that language.
So you get around it because the power, first of all, is retained by the chief of fire. You have the second-class cities law also referencing.
Or police, because remember, we're arguing both.
Yes, right, exactly.
It's the same issue.
Yes.
Yeah.
So you also have the second-class cities law itself. When discussing the powers of the Commissioner of Public Safety, Section 133 of the second-class cities law references the civil service law. So does that mean that the second-class cities law is somehow subservient to the civil service law because it's referenced? So are the powers of the Commissioner of Public Safety, which are outlined specifically in the second-class cities law, diminished because that provision references the civil service law? And I think the answer is no. And it's the same here. You have the powers enumerated, the powers given to the chief, and then you have guides for the chief. The guide is that the chief has to follow these rules and regulations of the department, other laws that might govern, including the civil service law. But I think it's important to also point out that there is no Taylor law, no bargaining obligation when the 1960 charter is enacted. So there's no way the city could have been agreeing to go along with or collectively bargain police and fire discipline in 1960.
But we have the crux of the argument, would you say, sir?
I think you do, but I think it's also important to point something else out. The municipal home rule law contains a provision regarding changes or supersession of state statutes. And it says that if you're going to supersede a state statute, then you have to explicitly do it. You have to make it clear. And I think it's important to look at the cases that explain the rationale for that rule. So in the brief, we cited the Barham versus City of Rochester case. The Court of Appeals explained the rationale as follows. Confusion would be intolerable if, in the case of every local law adopted throughout the cities of the state, no one could feel confident that the local legislators had intended to supersede an entire statute or only part of it. If a part, which part? The purpose of this rule is to compel definiteness and explicitness in order that clarity should result. This is the exact situation we're in, where we have a charter provision and it's not clear. I mean, we would argue it was clear. They're arguing it's clear, but it's not clear whether that provision supersedes the state law. This is the exact purpose of the municipal home rule law section.
I think we have that.
Okay.
Anything further?
Well, Your Honor, just one specific issue related to the fire department. There was an issue raised at the conclusion of the fire department's brief regarding whether this line of cases, the matter of Patrolmen's Benevolent Association, Tunnel Wall, Cale City of Schenectady, whether those cases apply to the fire department because they specifically dealt with the police department. I would just direct the court to the case we cited from the first department, matter of Roberts, 113 AD 3D 97, which clearly addresses this issue of whether fire departments are quasi-military organization and whether or not, in that case, the court invalidated an existing.
You probably like the fact we call these cases together.
Thank you.
Yes, thank you, Your Honor.
Why don't we have, who should go first? Mr. Lambright, why don't you go first?
Thank you, Your Honor. For the plaintiff respondent here, Local 280, since we have two plaintiff respondents. Judge Karolounis got this case correct. And you did get the crux of the case, which is what happened in 1960. Clearly, based on the Common Council minutes that we pulled up and the clear wording of the
Both sides says the
charter.
language is clear unless we disagree with you, and then it's confusing.
Well, when you look at it, Your Honor, when you look at it, it says, all laws and parts of laws enforced when this charter shall take effect are hereby superseded, so far as they affect the city of Syracuse, to the extent the same are inconsistent with the provisions of this charter.
This is a straight-up question of law that we've got to take a close look at in light of the Court of Appeals cases.
You do, of course, but what I think the city is asking you to do is say that every provision of that 1.5-inch charter, every provision needs to specifically state it's superseded, as opposed to what this charter did in two separate places. Say the entire charter that pre-existed this is superseded. So if you were to take their argument, each provision would have to be specifically stated it was superseded, which would invalidate the entire document virtually, because no other provision says that it's superseded. I would also raise, and this was not addressed in Judge Karolounis' brief or our papers, of course, was a very well-reasoned decision by you guys, and that was the Rochester police locust case, which really gets in the deep weeds of how this should work, whether or not the pre-existing law was in force when the city made this action. So we're talking about, he says, Taylor law wasn't in effect. Well, this law firm's been representing this union since 1970. I can tell you for the last 50 years and the last 20 of my career, we have negotiated discipline. This is the first time the city's taken this position that these discipline procedures didn't apply. Lastly, with respect to the position on the fire department, the Court of Appeals has not ruled on this issue. Yes, the first department has said this line of cases applies, but the Court of Appeals hasn't. And I believe that first department decision was wrongly decided.
Thank you.
Good morning, Your Honors. May it please the court, Kenneth L. Wagner for the Syracuse PBA. My comments echo Mr. Lambright's, my partner. Judge Karolounis charted the correct course for resolving this case at Supreme Court and now before this court. And the crux of the matter is, as you said, Justice Curran, just a couple of points. The Schenectady Charter did not do what the 1960 Charter did, which was to contain repeated expressions. I would count 3 or 4 places where it specifically referenced supersession.
And the parties have provided us with that background information in the record. We could look it up ourselves, but I know it's there for our benefit.
Yeah.
Thank you.
Yes, Your Honor. And then, of course, the civil service law is specifically referenced that the procedures would be followed. The procedures of the civil service law would be followed. At that time, in 1960, Section 75 and 76 had been enacted in 1958. That was inconsistent with the charter. So the idea that this reference to civil service law somehow didn't impact what the chief of police or the chief of fire could do is just not well taken. And then, Your Honor, of course, it's true that the bargaining obligation didn't exist. That was several years down the road. But the city didn't need to say, yes, we want to bargain with the future union of the firefighters or the police officers. What it did was supersede the second-class cities law. And then once that's superseded, it's out, period, because of civil service law applies. Now, the Common Council, the Revision Committee, and the voters constructively are charged with knowing that the civil service law could be amended. And in fact, it was 7 years later. And at that time, the city became obligated to bargain. With that, we'd rest on our brief.
Thank you very much.
Thank you.
Mark Mario versus New York State Division of Human Rights.
Good morning, Your Honors. May it please the court. Charles Steinman on behalf of Mark Mario, the petitioner appellant herein, who's present in the courtroom today with me. Your Honor, there are 2 principal issues I believe that are identified in the respondent's papers, which I'd like to address. First is that the ALJ's determination that the violations, which are extensively documented and were the subject of a multi-day hearing, did not constitute a continuing violation. I respectfully disagree with that conclusion. It actually began before Mr. Mario even got there. Before he actually commenced employment, the testimony was uncontroverted that a coworker of Mr. Mario's outed him as being transgender before he even got to the pharmacy at Mohawk at which he was to work in 2011. It just got worse from there. A coworker testified, I'm sorry, he did not. The coworker did not testify. There was testimony that coworkers referred to him as disgusting, sinful, repulsive. Okay? There's no testimony that there's anything sinful or repulsive or bad about him other than the fact that he was transgender. If you look at page 42 of my brief, and I won't trouble the court with going through all of it, I've listed.
Yeah, we can look that up.
Thank you, Your Honor. So to say that all of these things do not constitute a continuing violation is a premise with which I find absolutely no foundation. The ALJ, and I believe respondents will put forth this theory as well. Well, they didn't say it directly to him. It just got to him. These were well-known things. They interfered with his work. They hid things from him. The pharmacy orders were hidden from him so as to negatively impact his job performance. I don't know what kind of proof is required to say that these things are connected other than they happened without interruption for a period of 7 years. If there is some standard which delineates between what is a continuing violation and what are merely isolated violations, the cases don't make that clear, at least to me. I submit that they are. So in that respect, to conclude that this pattern, this lineal pattern of discrimination was not a continuing violation, I think is erroneous. And the conclusion that that reaches is that these all things were all time barred. And that was what I believe the ALJ premised his decision upon, or one of the bases for the ALJ's decision. And again, that is wrong. So if you are able to look back at the 7-year pattern of harassment,
And
discrimination.
we'll look into that.
Yes, Your Honor, thank you very much. Then we get to the issue of whether or not this constitutes a hostile work environment. I think the best thing I can say about that is it was so hostile, other people couldn't even stand it. We have the uncontroverted testimony of Ms. Brown, was that it was so, and she characterized it was so bad that Mr. Mario couldn't make a piece of toast without being harassed and criticized. She quit because she couldn't stand it. That, I think, is the definition of what a reasonable person's tolerance for this hostile work environment could be. It's so bad, even other people quit. With respect to the issue of the rebuttal testimony, this is a very interesting issue. The ALJ at one juncture said, well, this isn't about his work performance, then permitted the respondent to introduce testimony about his work performance. And then, when counsel, Mr. Blood, attempted to introduce rebuttal testimony, it was disallowed. And the respondent's position is, well, Mr. Mario could have testified to it. How could he? It came up in the respondent's case. And the documents, the computer printouts, are extracted from the Department of Correctional Services' own DBase.
Can I go back to your hostile work? Let me just go back to the question of the hostile work environment. If we disagree with you that the incidents that occurred outside of the 1-year period are linked so that we can consider them, are the incidents within the 1-year period enough to establish a hostile work environment?
The 2 in 2017, Your Honor?
Yes.
Yes, I believe that
There's
they are.
3. I actually thought there were 3, but maybe, yeah.
I believe that there were 2.
2, okay.
Yes, I submit that they would be sufficient standing by themselves. Yeah.
We'll look into all that.
I'm sorry.
We'll look into all that.
I know the court will. Thank you. As I said before, with respect to the with respect to the rebuttal, this was documentary proof. This was extracted from Dox's own computer base. So I think that the respondents come to court with unclean hands for them to suggest this is proof that Mr. Mario could have testified to, could have brought in his own case. When the ALJ was saying this isn't pertinent, they bring it out and then we can't respond.
Thank you.
Thank you very much, Your Honor.
Go ahead.
If it please the court, Aaron Waskoff for the New York State Division of Human Rights. I believe that the court can see that the record demonstrates substantial evidence to support the commissioner's determination. There is a 1-year statutory look-back period from the date of filing a complaint with the Division of Human Rights in order for any acts to be considered as violating the human rights law. However, the division can consider acts occurring beyond this 1-year statute of limitations period if they are part of an ongoing policy or practice.
We understand that.
Okay. I think that this 1-year period is certainly important. We bring it out in our brief in that there needs to be acts that are consistent with the acts occurring prior to the 1-year period in order to consider a policy or practice as violating the human rights law. And what we have here is, I believe it's 3 acts. There's the March and April reviews, and then there's the tool inventory, scissor inventory, and none of those acts could be considered discriminatory or harassing. So without something during this 1-year period, the commissioner's hands are tied from going back before it.
So your point is if there's no proof during the 1-year period, or if the proof doesn't rise to the level during the 1-year period, there can't be sort of a continuing violation because there's not a violation within the statute of limitations.
That is correct. And
I think we understand that.
okay, we're not even saying that was the prior acts were part of a continuing violation.
But your point is that, I'm sorry.
No, go ahead.
Your point is that they can't even be considered, or they shouldn't be considered if there's nothing during the statute of limitations.
Our point is that the commissioner's hands are tied, where even if she wanted to consider things before the 1-year period, by statute, she is not able to.
I think we understand that.
Okay. The only other point that I want to make is that it is the commissioner's role and prerogative to assess credibility. And I think we bring out in the brief, and you can see in the order, that credibility findings were made, and that is how the commissioner looked at the prior period.
Thank you.
Okay, unless there are any further questions, division would rest on its brief.
Thank you.
Thank you.
Good morning. May it please the court. Kevin Hu on behalf of Respondent Docs. I intend to rest on my brief, but if I could just make 2 brief rebuttal comments. The first is that we agree with petitioner that the critical issue before this court is the continuing violation doctrine. Without these untimely allegations, petitioner's claims ultimately fail. And it is enough to note here that petitioner relies solely on the evidence that was favorable to him in the record. That is plainly insufficient under the substantial evidence standard of review. This court must determine whether the commissioner's determination is supported by the record, and it plainly is. It is enough to note here that Docs presented evidence, that competing evidence with respect to nearly every single allegation of alleged discrimination. And on that basis, this court should affirm. And finally, with respect to the rebuttal evidence, it is undisputed that petitioner was aware that his performance was at issue in this case. And that is actually reflected in the testimony. On direct, he defended his own performance, and I believe his counsel actually used a subset of this same data he now claims he was unfairly precluded from using. And also his counsel cross-examined both the petitioner's supervisors about the basis for their subjective belief that petitioner was not performing up to standard. And so under these circumstances, it was entirely fair for the ALJ to conclude that petitioner could and should have introduced that rebuttal evidence earlier in the hearing. Unless there are any further questions, I rest on my brief.
Thank you. In the matter of Joseph Gasparino versus Town of Brighton Zoning Board of Appeals,
Good morning. May it please the court. John Mancuso for the Town of Brighton Zoning Board of Appeals. Supreme Court in this case committed reversible error by substituting its judgment for that of the zoning board. Rather than affording deference to the board, which is well established under many precedents of the Court of Appeals and this court, the Supreme Court clearly, if you look at the decision, engaged in its own balancing test. It looked at the evidence itself.
Sir, do you want to address the fact that the ZBA in its decision did not specifically address Factor 5?
Yes, Your Honor, happy to do that. In annulling the zoning board's decision, we submit with respect to failing to make a finding on the self-created hardship, the Supreme Court violated 2 fundamental issues of law. One, no one factor is determinative as to whether to grant an area variance. And the second issue is that the zoning board doesn't need to justify its conclusions with respect to evidence as to all 5 factors, as long as looking at the record as a whole, they sufficiently balance the relevant considerations.
The record would reflect that the ZBA was aware of the fact that the property owners had notice of this restriction when they bought the property. So this issue was before them.
Yes, Your Honor. This issue of self-created hardship, along with every other factor, was in the record. It was before the zoning board. And I would submit, as is arguably true in the vast majority of zoning cases, self-created hardship is something that is arguably self-created by the applicant. But in this particular case, I think it is critical to note that the zoning board found that the other four factors, all of the other four factors, weighed in favor of granting the variance. And so what you have then is a situation where if you accept the Supreme Court's rationale, you're effectively allowing the self-created hardship factor to override the entirety of the findings of the board. And that is simply unsupported by New York law. And so we find that to be a reversible error. And then to circle back to the substitution of judgment issue, again, as I submit in my brief, which I will not reiterate in total, in every single facet of the balancing test, clearly the Supreme Court had its own opinion about the evidence contrary to what the zoning board found. But it is clear that the zoning board is not required to accept the unsubstantiated testimony of the public or the general community opposition. It is in charge of weighing conflicting proof. It is in charge of weighing credibility. And here the Supreme Court substituted its judgment.
That issue kind of rears its head on the question of drainage. I think both parties seem to say in a conclusory manner that it would have an adverse effect or would have no effect. There was no engineer report or anything like that. There's just the testimony of the parties involved, but nothing further. So the ZBA used their own judgment, apparently.
Exactly right, Your Honor. Couldn't have said it any better. So with that, unless the court has any further questions, we will rest on our papers.
Thank you.
Thank you.
Go ahead.
Good morning, Your Honor, and may it please the court. My name is Jacob Zoglin. I represent Dr. Susan and Joseph Gasparino. The Supreme Court properly granted the Gasparino's petition, and so its decision annulling the ZBA's issuance of the area variance should be affirmed. There are three reasons I'm going to focus on today. First, the ZBA failed to consider each of the required factors, as Your Honor pointed out earlier. That included
did they fail to consider it, or did they fail to articulate it in their finding?
Your Honor, there is no evidence in the record that they considered the self-created hardship factor. They
did say they considered all the hearing testimony, that they considered everything that they heard. They said that.
The ZBA secretary said that they considered factors. He didn't identify which factors, and the transcript, which
we considered the statutory factors, I think is what he said.
He didn't say which factors they considered.
But he said the statutory.
Right, it's a conclusory, it's a legal conclusion that doesn't identify the basis of his conclusion.
Okay, we'll look at that.
But again, they don't have to articulate their kind of fact-finding, the facts with respect to each of the factors.
But
you agree with that?
They don't have to articulate it, but they must consider them.
Right.
And the certified administrative return for this proceeding unequivocally shows that they did not deliberate on those issues. There's no discussion in any of the record whatsoever that they deliberated on the self-created hardship.
The issue about whether the hardship was self-created was raised during the hearing.
That's correct. And so it's part of the administrative record, meaning they must have considered it. Or no, they had a duty to consider it, is what I'm saying. And I mean, the way that the ZBA is presenting this is, oh, it was part of the record, so they did consider it. Not so.
Wasn't that what the Stefano affidavit said, though, that we considered all the factors, the statutory factors?
He didn't say all. He said we considered statutory factors. He didn't identify which ones. And
there's no question that this issue was in the record, however. The ZBA was aware of the fact that the Halls bought the property with knowledge, at least constructive knowledge, of this restriction. They were aware of it.
There was evidence presented of this, and the ZBA ignored it.
Okay. Well, I think we understand your argument. We'll have to look at that.
Okay, and I'll just want to add that in reaching their conclusion, the ZBA specifically said that they were ignoring all the evidence in opposition because they blanketly characterized all evidence in opposition as not evidence, even though it's undisputed that it was offered by people with firsthand knowledge that spoke on specific items, drainage, sight lines, emergency response, some of the factors identified in 267B. This is not generalized community opposition that says, I don't want this in my backyard. This is specific firsthand knowledge with identified issues that will affect the community. The second issue that I would like to discuss today, before I move on to that, if it's okay, I'd like to hit a couple of the facts that I think go to the self-created hardship factor. The ZBA repeatedly admitted in its briefing that it did not make any findings on it.
We understand that they didn't make any findings, but that doesn't mean they didn't consider it. So we understand all that, okay? Why don't you move on to your next?
Thank you, Your Honor. My second point is that the ZBA granted a larger variance than was necessary to achieve the benefit sought. The benefits sought by the applicant included a third garage bay and an extra bedroom. There was evidence presented at almost every level that these things could have been obtained without a variance. For example, the halls admitted there was room in the back of the home to add a structure.
Okay, you don't have to read.
Oh, okay, that's at okay. The halls also admitted that they could create more space in the backyard by moving some shrubs. That's at 140 to 141 of the record.
Could the ZBA conclude that the alternative plans were either not feasible or cost prohibitive?
They didn't specifically consider any of these specific locations. As far as I know, there's no evidence in the record that they deliberated on any of these specific ones raised, even though they wouldn't have required a variance. And I will point out, Your Honor, the ZBA made that finding without considering any alternative that wouldn't require a variance, because the standard is the minimum variance necessary. And so if any of the items could be placed in a different location that would require less of a variance, they're required to consider those and impose them. So, for example, in the backyard adjacent to the great room in the library, there's a big open space that could put another bedroom. They could convert the existing library in the home to an extra bedroom. I mean, if your concern is enough room for your kids, maybe you don't need an extra library, maybe a bedroom is more important.
Again, but isn't the ZBA, isn't it within their discretion to conclude that those alternative plans are just not feasible?
They didn't consider any alternative plans for which a variance would not have been required, though. They didn't do that, which is one of the factors is whether the variance can be obtained without a variance.
Okay, yeah, I think you've gone over that, and we will look at that very carefully.
Okay, and the last other point is the location on the opposite side of the garage for the third garage bay wouldn't have interfered with the side setback. And if you look at record 321 and 319, the plot plan and the first floor plan, those show more than enough room, and those plans are superimposed over the lot line so you can see there's enough room. Even if they were to consider those things, it's arbitrary and capricious to say, oh, there's no possible way to situate these when they haven't even evaluated them.
I think we have your argument.
Thank you, Your Honor. And, lastly, I want to respond to an argument that's made in the ZBA's briefing. They keep trying to argue that we're trying to articulate the practical difficulty standard. That's not so. We specifically, and so did the lower court, applied 267D. In 1995, after the five-factor test for area variances from 267B was adopted, the Court of Appeals in South v. Osgood applied that test, and they held that the area variance applicant's self-created hardship existed because he purchased a substandard lot for which from which the variance was requested. Similarly, in 2018, the second department determined that the applicant had a feasible alternative use of the property other than a variance because it could construct one house instead of two. The court further held that having purchased the lots as one parcel under the existing zoning code, the petitioner is charged with knowledge of the zoning restriction and is bound by them. Those cases, even though they those cases, because they're after the 1991 amendment, show that that we're not applying the practical difficulty standard. To the extent that any of the language is the same from before, the Court of Appeals decision shows that that's because there's similar language between the old standard and the new standard, which is why they wanted to create.
I think we understand that.
Thank you, Your Honor. The last thing I'd like to do is quickly respond to some items that were raised during argument just now by the ZBA. There's no evidence that the lower court substituted a judgment. This is not an issue of one factor being, an issue of determining the entire area variance application. It's about the ZBA not considering each of the 5 factors.
Okay, you've already gone through that.
Okay. The ZBA claimed that the ZBA made a finding that the other factors outweighed the self-created hardship. It made no such finding. That argument was raised for the first time during the Article 78 proceeding, and an argument raised for the first time like that in Article 78 cannot possibly be binding on an opposing party, nor can it possibly be the basis of the ZBA's original decision. It never reduced that to writing either.
You should.
Unless there are any other questions, I'll rest on my paper.
Thank you.
Thank you, Your Honor.
James Bonner versus Suzette Bonner. Are you? Apparently Justice Kern is recused on this matter. Go ahead.
Thank you, Your Honor. Good morning, Your Honors. May it please the court. We have a case here where a mother has been removed as co-guardian and co-trustee for her disabled daughter.
Okay, let me ask you this question. Shouldn't there have been a hearing on this?
Absolutely, Your Honor.
So the bottom line is, whatever happened here, we needed a hearing.
Well, actually, Your Honor, on the issue of actually removing the appellant as guardian and trustee, there absolutely had to have been a hearing.
Right.
However, there's ample grounds that the court should have granted our motion to dismiss based on the petitioner waiving the issue of the mother's felony conviction. He was aware of it for the daughter's entire life and only raised this ground after the parents were divorced. And also, in addition to the mother now having a certificate of relief from disabilities, the conviction was actually disclosed to the prior surrogate when the mother and the father were appointed guardians in 2011.
We understand all that.
So the surrogate has actually already made a determination that the mother should still be a guardian and trustee in spite of this conviction, and the certificate of relief from disabilities resolves that issue.
Look into that. Thank you.
Unless there's any other questions, I'll rest on our papers.
Thank you.
Thank you.
I will put the question to you as well. There needed to be a hearing.
Yes, Your Honor, may it please the court. We'd take the position that a hearing was not required for a few reasons. First, the appellate has presented this as a motion to dismiss that was converted into a motion for summary judgment, and that's not what occurred here. The court has sua sponte removed the appellant because at the time she was appointed, she was legally ineligible to be appointed as a fiduciary. This isn't a question about whether she is now eligible. She has been removed because at the time of the appointment, she was legally ineligible. This doesn't mean that the appellant can't petition the court to be reinstated based upon a certificate of relief from disability. And in that case, the court should have a hearing to determine whether, based upon that certificate of relief from disability, she has been relieved from this specific disability. And if so, whether she is otherwise eligible to serve in a fiduciary capacity. And if so, whether she is suitable to serve in the best interest of the ward.
Again, you need a hearing.
Correct, Your Honor, but I would submit that the hearing isn't in this proceeding. It's in a separate proceeding commenced by the appellant to be appointed properly as a fiduciary of the trust and as guardian of the board. Just quickly on the issue of whether the certificate of relief from disability supports a motion to dismiss. It does not. A certificate of relief from disability, according to the corrections law section 701 subsection 3, states that the court still has discretion whether to address or to appoint a convicted felon as a fiduciary.
Thank you. Thank you. Jacqueline Duval versus Delta Sonic Car Wash Systems.
Good morning, Your Honors. May it please the court. I'm Stephanie Palmer. Your Honors, I will rely on my brief, but just briefly, I want to point out a couple issues. The defendants moved for summary judgment solely based upon a storm in progress theory. The lower court dismissed that part of plaintiff's complaint and said that the storm in progress completely alleviated the defendant's responsibility, which is not true when an incident occurs inside when there's inclement.
But that's not really what the court said. The court dismissed that theory, if you will, but it kept in place that part of your claim that claimed that there was negligence for allowing the substances to accumulate, the wax and that sort of stuff. So that part of the case was left alive.
That's right, Your Honor, it was. But our contention is that even though they dismissed part of it as it relates to storm in progress, that it's our contention that they misapplied the storm in progress doctrine. The storm in progress doctrine does not alleviate the store owners from all responsibility. The store owners still have to use reasonable care under the circumstances.
It eliminates the duty until they have an opportunity to, until there's kind of a cessation of the storm, so to speak.
Well, I beg to differ, with all due respect. I think the storm in progress doctrine, and it seems with the case law, says outside is a little different as to how they have to handle it inside.
Well, but there's lots of case law that if you bring in the precipitation into the lobby area, the storm in progress doctrine still applies.
Well, it says that they have to use reasonable care under the circumstances. So we're not asking them to put mats down throughout the whole hallway as in this instance. We're asking them to maybe put a mat down where the patrons are required to come into the facility. We're not saying that you have to put fans out all over or cones every 2 to 3 feet, but even if they put one cone out in the 60-foot hallway, they did nothing, absolutely nothing, and I think the video shows that. It wasn't until...
The question is whether they, with respect to the precipitation, with respect to the rain and snow that was going on outside, the question is whether they had to. If the duty hadn't kind of recommenced because the storm was still in progress, they didn't have to do it. They don't have to do anything until they can.
I believe that what they have to do outside, because the storm in progress doctrine is a little different from what they have to do inside when they're inviting the patrons inside.
So you dispute that kind of interior areas come within the storm in progress doctrine?
I dispute it to a certain extent, yes, Your Honor, because I think the case law out there is saying if it's in the area, like there was cases about getting on a bus, there's constantly people in and out. So they can't do everything to keep track. It would be unreasonable for them to do something, to have to get in between each patron and maybe clean down the steps, or there's
kind of the whole
cases
theory
out there
behind the storm in progress doctrine, isn't it?
Well, that is. However, the circumstances are a little different. It's what is reasonable under the circumstances. And I don't think
you only get to that question, as Justice Periodata points out, if there's a duty. If the storm in progress defense operates, there's no duty. It negates the duty. And there's tons of cases that say that. So now then the question is, do you shift to say, well, it's because it doesn't apply to inside areas? Well, clearly it does under the case law. So forgive us for not understanding exactly where this slices in the case law that's pretty well established.
And that's where I think there has to be a little bit more distinction in the case law. I agree that the
You
storm.
want us to make new law on this?
Absolutely, Your
Why
Honor,
not?
always willing to do that,
Okay. Well, I think
as long as it's reasonable.
Okay, I think we have your, I think we have your argument.
I think so. Would you like me to address the cross appeal? Just briefly, no, you don't
No,
want
it's
to.
a
Oh, I'm
briefly,
sorry. Just briefly.
Okay, no, it's hard to hear me. I didn't get it.
On the cross appeal, I think the defendants had the burden to, when they bring a motion for summary judgment, to establish that the plaintiffs have raised no triable issues of fact.
They didn't
And
even address your
they
alternate
did not
theory.
address it
And they're
until
moving
the
forward.
reply.
Right.
I know that they've argued that the plaintiffs sort of put in a Hail Mary attempt in the motion, but that's just absolutely incorrect and not
If we were to
true.
address it now, it would be unfair to you.
That's correct, but even so, it was in the amended complaint as well as the verified
bill
bill
of
of particulars.
particulars,
It's
it was.
replete with mentioning of a wax or armor all type substance on the floor, and also in the questioning. We did question defendant's representative in regards to whether he had any booties or any protective wear on his
It's in the
shoes or
pleadings.
boots.
It's in the pleadings.
Right.
Yeah.
So we understand that.
All right, thank you, Your Honors.
Morning, Your Honors. Justin Hendricks on behalf of Delta Sonic. May it please the court. You've all clearly just discussed the storm in progress doctrine, so I won't bother addressing that unless there were any questions, which I doubt there are. As far as our reply brief is concerned, the case law relied upon in this area specifically mentions when new facts are introduced or new exhibits are introduced or new affidavits are introduced or when new relief is requested. None of those things happen. We brought a motion for summary judgment to completely dismiss the complaint.
Yeah, but you did not address the theory relating to the slippery substance, so to speak.
And that's because that theory was not pursued for over 2 years after the deposition.
But it was
of our
in the
plaintiff.
amended complaint, it was in the bill of particulars, it's in the pleadings.
And you still have a chance to go after it if you need to, right?
I'm sorry, Your Honor.
Another motion at the end of proof at trial. I mean, you didn't move on because it was dormant, according as I understand your argument. But then if we address it based on your reply, it seems very unfair to the other side because they don't get a chance to put anything in, correct?
But that is not the case here because there is no proof in the record of the existence of some foreign substance other than the plaintiff saying that the floor was shiny, water could make it shiny,
Well, no,
and that she
your-
noticed something sticky and
Your
the
employee
water could make it sticky.
talked about how the employees would go from one area to another, from one work area to another. They didn't have booties, there were no mats, and so there's clearly some proof on the record that wax or the substances from the repair areas could have come into that hallway.
But that's a hope and a prayer, Your Honor, with respect, because there is no actual
No, it sounds like a
evidence of
question
any
of fact
wax
to me.
coming. Like, I was just saying, but there is no actual evidence of any wax or Armor All or grease that, no one actually pointed to it and said, that was waxy.
That should have been part of your motion.
And it was brought
It
up
wasn't.
in opposition, which is why it's not unfair that we then responded to it in the reply. That
Okay,
this is not a
I think
situation.
we have your argument. Thank you.
Thank you, Your Honor.
Anthony Costello and Son versus County Monroe Industrial Development Agency.
Good morning, Your Honors. Anthony Adams appearing for the appellants, Costello Companies. To please the court and counsel, I'd like to focus my argument on the lack of any notice or any process that preceded this alleged termination of the tax exemption agreements that the parties have negotiated for the Costello's project. Let me start by saying this. This comes before you on a motion for summary judgment. This is not a case where there was a trial. In fact, there isn't even a disposition in a typical Article 78 proceeding, which this is, because the motion for summary judgment was made before that determination could ever be made. So the standard of review here is the summary judgment standard of review. We showed through an affidavit, a verified petition of the managing member of the Costello Companies, supported by an affidavit of the Vice President of Operations, Attorney Michael Townsend, who participated on Comada's behalf in negotiating the original documents in support of our position to support our claims in the verified petition.
Okay. As far as I have read your paper, my understanding is that these agreements required you to pay some money.
That's right, Your Honor.
And I think that the evidence in those papers were kind of clear that you paid no money.
Well, it's true.
I mean, so what I'm saying is, summary judgment seems to be the proper vehicle when we have the facts that you were supposed to pay some money, you paid no money, and we determine as a matter of law whether that was a correct position for you to be in.
Well, that's respectful, Your Honor. Had the motion been for summary judgment, for a money judgment against us for the unpaid pilot payments, I would agree with you. But that's not what happened. They didn't bring an action. One of their specific remedies under the pilot agreement was to bring an action for a money judgment, interest, penalties, and attorney's fees. In fact, that was one of the limited remedies that the agreement gave them. Instead.
Wait, there's other remedies. It's not just one of those remedies that.
Well, Your Honor, I disagree. But I'll refer to my brief on that. I really like to focus on the notice and process argument, because Comida is a public benefit corporation. This wasn't a contract between private parties. This was a situation where Comida agreed to grant tax exempt status to this real estate project in order to induce investment. Pardon me?
We understand that.
All right, so it's not a private deal. They're subject to Article 78 review. By statute, they're obligated to operate pursuant to certain published procedures. By statute, they operate through a board. They don't operate through an executive director. They don't operate through a council. Their board of directors acts on behalf of Comida by statute. What the proof shows here is that while the parties tried to negotiate a repayment plan, that foundered. It foundered, frankly, because the city took the unreasonable position that they would only agree to a plan if there was also an agreement to modify previously signed documents. That's why the thing is foundered, not because Costello's wouldn't pay. They tried to pay, but the city conditioned that.
So you're jumping to the second contract, okay?
Pardon me?
You're jumping to the second, the attempted second contract, a renegotiation of the terms. But the original terms that required you to pay something, you didn't pay anything.
We didn't. That's right, Your Honor.
And then you wanted to renegotiate, but you're talking
We
about.
we didn't want to renegotiate. We did not. We wanted to pay what was due. They wanted to renegotiate.
Why don't you listen to.
What's the evidence that you wanted to pay what was due? Because that's what I found pretty lacking in your papers.
Well, there's an affidavit from Mr. Townsend indicates that they had made several proposals to repay the delinquent amounts, but that no agreement could be reached because the city said, no, that's not good enough. We also want to defer this special financing piece that was supposed to start in July 2017, but we're not willing to do that anymore, even though the signed agreement required it. So it was, we were trying to negotiate a repayment plan.
So let me just stop you for a second. You don't dispute that you were in default, right?
We don't dispute that we were in default in making 3 payments.
Okay, so the agreement provided remedies on default.
That's right.
One of which allowed any action to be taken that was necessary to cure the default. So
to cure the default. Termination doesn't cure the default. Termination perpetuates the default, memorializes the default. That's not one of the remedies that was allowed. But again, I keep coming back to the process.
It's a common law remedy. Termination is a common law remedy, isn't it?
It would be if it were preserved, but this contract says, in a clause called remedies, in the event of default, the city may exercise one or more of the following remedial steps.
And read them.
It lists 3. Declare a default. Take any other action to cure any such default.
Well, the default is cured, I'm sorry, Your Honor.
Go ahead.
The default is cured by the fact the agreement's over.
Yeah.
The money's still owed. It's never been paid. The default's never been cured.
It's cured by the fact the agreement's over and they're freed from the obligation to provide pilots.
Well, we're being sued for the unpaid pilot payments in another action right now. It's still not cured. Again, let me please focus the court's attention on the process. The IDA has a process, a published process. The IDA board has a published process.
And your argument is that they didn't cure the default.
No.
But they're not, their
No.
job is not to cure your client's default and failing to make
No,
payments,
that's right, it was not. Their obligation was to give us written notice. They have two steps. They have a default review committee, a compliance review committee that reviews defaults and considers whether or not some sort of relief from the default is warranted, or a waiver or renegotiation. That's one of their obligations that's in the record at 129.
We understand that.
They didn't do that. And what it specifically says is, when every year this compliance review committee meets, the executive director, who's a staff member, is supposed to identify projects that are in default, like this one, are supposed to find out what the problem is and report back to the committee.
Okay, we understand all that.
Well, they didn't do that. They didn't do that. And then, when the committee reports, the board is supposed to meet. And there's a specific policy on this, at page 127 in the record. And here, the board is to consider, when there's a default brought before them, they're to consider whether there are extenuating circumstances, whether a waiver is warranted, whether a renegotiation of the terms is warranted, and they didn't do that. And the IDA, the policy says the IDA shall give notice, the IDA shall do this, the IDA shall do that. But then it says specifically, the board, but these factors that may excuse a default or warrant some other remedy, these factors should be discussed and predetermined to the extent possible by the board. The board had an obligation to.
I think you've been over that over and over.
All right, but what they didn't do is, they didn't give Costello a chance.
We got that argument, okay?
Well, okay, it's only because it's in my brief then, because I haven't addressed it. Costello never had a chance to speak to the board. Costello never had a chance to speak to the committee. That's the point. Never had a chance, never knew they were even considering this. Not until they got the letter from council that said, you've been terminated. The other thing that I think is an important point is, I think the record supports this. The IDA completely delegated their role here to the city. The city was driving this train. The city wrote a letter that said, we're going to ask for termination. Kamada said, the executive director said, okay, since the city wants it, we're going to do it. You'll see there's in the record, there's no evidence, frankly, that the committee or the board itself ever actually reviewed this project. They reviewed, the minutes say they reviewed some projects that were in default. The minutes say they authorized various actions. But all we have is the executive director's letter saying, we're terminating this. And the only reason he did it, and he admits it in his papers, is because the city told him to. So I think that's an important violation as well.
Thank you.
Good morning, Your Honors. Patrick Beeth for the City of Rochester. It's clear from what we've heard so far that no payment has ever been made under these pilot agreements. Respondents' papers, both for the city and Kamida, make perfectly clear that we retained a common law right to terminate in the face of default. We had a default that extended over years. We gave clear notice that the city was going to ask Kamida to terminate the agreement, and there was never a cure for the non-payment.
If there was anything paid, correct?
Never anything paid, even if there were some merit to the argument that all Costello ever owed to the city was 25% of that pilot payment. Not even that 25% was ever tendered. There was never a realistic offer to the city. There was never a check offered to the city for the city to take under protest or otherwise.
Deferential standard review in this Article 78 proceeding, correct?
That is right, Your Honor. Unless the court has any other questions, I'll rest on my papers.
Please, the court, Philip Spillane from Harris Beach for Kamida. Counsel for the Costello entities quoted paragraphs A and B of Section 15 of the Kamida, of the pilot agreement, which is at page 70 of the record. A says, yeah, one of the remedies is give written notice. B, take any other action necessary to cure. That's what he focuses on, cure. And C, which he didn't mention, says take any other action at law or equity which may appear necessary or desirable to collect the payments. They have common law remedies, as Justice Joseph said. With respect to the procedures and the claimed procedural default, I respectfully submit to the court that the Adair affidavit, he was the head of the IDA, found at page 283 to 289 of the record,
which is unrebutted, details in exhaustive detail all these meetings that the IDA and the city had with the Costello entities trying to cure this. Even after the termination, they offered to sit down with them.
So we should apply our deferential standard of review in this Article 78 proceeding.
Yeah, sure. And in essence, the court below got it right. Very, very briefly, this Townsend affidavit. Townsend affidavit relies on two instances of hearsay. One is he quotes Ed Kelly, who was an attorney with Bond Shenik, who was representing Northwestern Bank at the time. Northwest walked away from this deal. And at one point, Kelly says, and it's in the affidavit, it's Exhibit C to the Townsend affidavit at 345 of the record, where, I'm sorry, at 326 of the record, Kelly says, I don't like this change to Section 16, which is the remedies of the PIF lender. And we're not dealing with paragraph 16, we're dealing with 50. But the fact of the matter is, who cares what an attorney for a bank that walked away from this deal as a lender objected to? The fact of the matter is, it had nothing to do with paragraph section 15, which is the section of the Commander Agreement, the pilot agreement, under which the termination was effected. So this reference, and then finally, at 345, Townsend refers to an email from Gordon Forth, who was counsel to Costello, saying, hey, I spoke with Curtin this morning, the city corporation counsel, and he's comfortable with this idea of waiving the termination. Curtin puts in an affidavit, says that's nonsense. I never agreed. I was never comfortable. I certainly didn't agree to waive the termination agreement. So that is unrebutted in the record. There's never anyone who can contest what Curtin said. Curtin explains it.
Okay, I think we have that.
Thank you, Your Honor.
Thank you.
And if there are no other questions, I will rest on that.
Anahita Alice Sajarian versus State of New York. I didn't get that even close. Can you pronounce that name for me?
Good morning, Your Honors. I'd like to deal with a number of the issues that were dealt with in my brief. I'm just going to highlight a few issues, and I shouldn't take full 15 minutes, but I must congratulate you on getting through this very lengthy calendar and what I believe is record time.
Sir, I wonder if I could sidetrack you just for a minute here.
I'm sorry?
I want to sidetrack you just for a minute here. I'll give you an opportunity to put everything in you want to talk about, but for the sake of our initial argument here, let me give you the benefit of no immunity, no qualified immunity, and maybe the photograph should have come into evidence.
Yes.
Let's just
I'll deal
give
with
you the benefit of that for a minute, and let's analyze this under traditional, ordinary rules of negligence. Let's look at it through that lens. And that brings me to the question of whether the state had actual or constructive knowledge of a dangerous condition. Let's just boil it down to that question.
Yeah, I'm
right
going
now for a moment.
I'll deal with all of those.
Okay.
Why don't you go right into that?
Pardon me?
Why don't you go right into that?
Yes. Well, first of all, as to qualified immunity.
I'll give you qualified immunity. I'll say that they don't have it.
Okay.
Let's put that aside. The state doesn't have immunity, no qualified immunity. Let's say this court made an error with not taking your photographs in, and let's analyze this under ordinary rules of negligence, which would require the plaintiff to show and to prove that the state had actual or constructive knowledge of a dangerous condition.
Absolutely.
Is there anything in the record to show that?
Yes. There's no question that the state knew that there were no lights in the underpass. And on February 17, 2015, the accident happened on June
A few months before the accident.
Yeah. They said they reviewed a request from the town of Amherst to add lighting, but they determined that the criteria for lighting was not met. Then on April 10, 2015, there was an email from the town of Amherst saying that it was important for the safety and aesthetics of pedestrians, cyclists, and vehicle operators, that there be lighting under the, they called it an overpass.
Correct.
For pedestrian safety and comfort.
Was there any evidence of any prior accidents, or did the university complain that their students were subjected to, some criminal activity, or that there was any motor vehicle accidents or bicycle accidents? Was there any evidence of prior incidents?
We did not present any prior accident data, which the court faulted us for. But the purpose of prior accident data is to put the state on notice of a hazard.
Right.
But it's not the only way. The court said that was the only way. It's not the only way, and even as the respondents indicated in their brief, if they're told that there's a hazard, then that's notice to the state. That's why these letters, there was an ongoing discussion and ongoing emails and letters between both Amherst and the University of Buffalo. That lights needed to be put in this underpass for safety purposes.
The town was requesting that for aesthetic and safety purposes.
Yes.
There's no question that correspondence was in there.
Yes. So they're on notice that
the town wants them.
That Amherst and the University of Buffalo both believe.
That does not.
Pardon me?
I didn't say anything.
Oh.
Judge Smith.
Yeah.
No, I had nothing to say.
Both believed that lighting was necessary for safety purposes. And that, we believe, certainly put them on notice.
Okay, that's what we have to determine. Okay, we have to determine whether that put them on notice or not.
Pardon me?
We need to determine whether or not that put them on notice. Do you have another point?
Well, it's in, all of these documents are in the record.
No, we understand that.
Pardon me? Oh, I'm sorry.
They're all in there. There's no question.
My hearing aids work a lot better when there aren't masks.
I sympathize with you, believe me.
But I think we have your argument there. Do you have any other arguments?
Right.
Yes. I mean, you have to put this in context. They're working on this road. They've already.
We understand all that.
Pardon me?
We understand all of that.
Yeah. So they know what's going on. The judge also faulted us for not presenting expert testimony on two issues. One was, how dark must it be to be a hazard? The testimony, which is uncontested, is that essentially it was pitch black at night under this underpass. And you don't need an expert to tell you that if something is pitch black, where pedestrians walking and bicyclists are biking and cars are going by, that it's a hazard. I mean, if it was.
Okay, I think we understand that. Do you have any other arguments?
Yes. The judge also said that they needed an expert to discuss what the highway design manual meant and what the purposes were. However, the whole issue of what a warrant is really should not be an issue here, even though the design engineer that testified said that that's just a suggestion or a recommendation. The clear wording of the design highway standard is very clear. It says lighting is considered warranted in all highway tunnels, which this is not, during both night and daytime periods. Separate
You don't
underpass.
need to read that to us, we have that.
Counsel, let me ask you a question. The bicyclist who struck your client did not testify, right?
I'm sorry.
The bicyclist did not testify, right?
That's correct.
So.
He defaulted.
I beg your pardon?
He defaulted.
Right. Well, you could have subpoenaed him to testify, but
Right.
in any event, the bicyclist did not testify. So how can we determine that the lighting condition had any causal effect on the happening of the accident?
Both Mr. Lamb and Anahita alias Garian testified to the lighting conditions.
No, I'm not talking about the lighting conditions. But what I'm talking about is we don't have any testimony, for example, from the bicyclist saying it was so dark, I couldn't see her.
I'm sorry, I can't.
We don't have any testimony from the bicyclist, for example.
That's correct.
That it was so dark where I was bicycling that I did not see her. There's no testimony in the record to that effect, right?
That's correct, except that's the reason why we believed the photographs that were not allowed into evidence should have been into evidence, because they clearly show the conditions. And the dark conditions.
We already know, okay, we got that. I think your time's almost up. Why don't you wrap it up?
I just want to say that the highway design manual is clear on its face, doesn't need interpretation, and it's directive. The authors of the highway design manual knew how to indicate if something wasn't, and we provided you with an example of that.
Okay, why don't you wrap it up?
Yes, but only as to the Nevis, the bicyclist's negligence, I just say that the dark conditions applied to him as well. All there was a white line.
We understand that, but what I
for the
believe
lane.
Justice Peredato is trying to say is we don't know if the dark conditions contributed to
That's
this.
right, and even if he is negligent, it's an issue of comparative negligence.
Okay.
It doesn't mean that the state is.
My question was really directed to causation, not negligence.
Yes.
So, do you have anything
Okay.
further?
No, that's it.
Okay,
Thank you.
thank you very much.
May it please the court, Frederick Brody for the state. Let me begin with notice. Claimant didn't show that the state had notice of a dangerous condition. The town of Amherst first mentioned safety.
Well, that's what we brought up before.
Right.
There has been nothing submitted that shows that there's any notice. It shows that they know it's dark and that the town and the school would have liked to have it light there, but there's been no notice that there were prior accidents or that there were muggings or something because it was dark. There's nothing shown, correct?
That's right, and I want to focus on this April 10th email that counsel's relying on. The April 10th email didn't give the state notice.
It just said that they wanted to have some light.
Right, it didn't say the condition in its present condition was dangerous. The town didn't tell DOT, get out there immediately and put in some lights.
Right, so your point is that the state didn't have any notice.
That's right. That is one of my points. And the April 10th email does not equal notice. All of the other materials from the town of Amherst are post-accident. And of course, claimant didn't show any similar accident had occurred previously. To the contrary, DOT's safety analysis, which is in the record, showed no prior accidents involving bicycles or pedestrians.
So again, they didn't have notice.
Right, and let me go to warrants, whether they were supposed to have lighting in here. The only testimony in the record on the effect of warrants was from senior highway designer Douglas Smith, who was called as an adverse witness. Smith testified that a warrant's a guideline, a suggestion, or a recommendation. And the highway lighting policy made that clear. It said lighting decisions must balance conflicting objectives. objectives such as safety.
Okay, you don't have to read through it all.
No, right. But my point is that makes highway lighting a matter of judgment. And once it's a matter of judgment, you go back to qualified immunity. And we have qualified immunity under Weiss versus Vogt because there's no evidence from the claimant that the state was negligent or that no reasonable highway designer would have adopted this design. Again, there is a policy judgment, there's a long safety report that's in the record, and you wind up with a determination that no further lighting is necessary.
Is there any explanation as to why? It was that the 75-foot requirement was met, the warrant advises or suggests that it should be there. The state just said no. Did they say no and why it's no?
Well, we can draw the reasons from the record. We know from the record that when the state made that determination, it had done the highway study, the safety study, and it found that the rate of accidents at this location was 1.76 accidents per million vehicle miles. The rate at other comparable locations around the state was 4.25. So more than double. So you've got something that's less than half of the accident rate for comparable facilities.
So also, in spite of the warrant, under the circumstances, they didn't feel it was necessary in this particular case.
Correct. And they're supposed to do that balancing. And just one last point, there's also a bike lane. There's a separate 5-foot wide bike lane that's separated from the sidewalk by, number one, a curb, so you have to hop over the curb, and number two, a 3-foot buffer zone where you're supposed to put snow. So you've got the curb, the 3-foot buffer zone, and then the sidewalk. So with respect to your Honor's question about Mr. Nieves, question isn't whether there's any evidence that Mr. Nieves, it was too dark for him to see Ms. Alias-Garriott. Question is whether it was too dark for him to see the bike lane, because he should have been in the bike lane
as opposed to on the sidewalk.
And because that's when they put the bike lane there, that's what made the road safe, or one of the many things that made the road safe. So unless the court has further questions, I'll rest on the briefs.
Thank you.
Court will stand in recess.